Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we continue our video series designed to educate and inform the public, so please subscribe to our channel. Amongst the things that appear in a lot of judgments of divorce, particularly for people whose marriage was of long standing, there may well be an alimony provision, what we call spousal support. An alimony provision that basically says that one person is going to assist the other in supporting themselves, not the children, but themselves, and they'll get a certain amount of money per month, certain money paid toward alimony. Years ago, the standard language in alimony in divorces for alimony provision would say something like this: the alimony is going to continue until a death or remarriage of the parties. So what would have to happen is, let's say husband's paying wife $1,000 a month alimony. It will continue, but if she remarries and therefore develops another potential means of support, the alimony cuts off. Another type of alimony might say the alimony will continue until death or remarriage of the parties, but for no more than 48 months. You know, there could be a time element. And years ago, there were distinctions between periodic alimony and alimony in gross. Nowadays, you're going to find the alimony provisions basically say the alimony is going to continue until further order of the court. Now, further order of the court is very open-ended. What will cause the court to make further order to modify the alimony? I will tell you very simply. The court's going to look to some significant change in circumstances that might well support modification of the alimony. So, for example, let's say wife was paying husband alimony of $1,000 a month. She had a good job, she was making money, and he was disabled. And 2 years down the road, he's still disabled, but guess what? So is she. Something happened, she's not working anymore, she doesn't have the kind of income. There's been a significant change in circumstances. She cannot pay it anymore. So it would be the burden of her attorney then to go before the court. She'd have to let her attorney know and re-engage that attorney to file a motion to suspend or modify the alimony, so that it is reflective of the reality that exists at that time. Namely, she doesn't have the money. She can't afford to pay it. There's been a big change in circumstances. Another possible change in circumstances, which is another reason why the alimony may be modified. Suppose on the other side, the job is the same, the ability to pay is the same, but the need has been reduced significantly. Why? The other person came into a lot of money. The other person did get a job, finished their education, now has a high-paid job, making more money than the first one, or inherited a lot of money, or for some reason the need isn't there. If that's the case, the court can be reapproached by motion and say, look, there's been a significant change in circumstances. He was a student then. Now he's got a high-paying job. He's making all the same amount of money as she is. You know, that kind of thing. So there's a significant change in circumstances, and therefore we want further order of the court. And the court can reevaluate and go through the prognosticator and determine the alimony should be lowered, the alimony should be suspended, the alimony should be whatever modification the court deems fit, but the court can modify that alimony based on that change of circumstances, either an upward or a downward modification. If you have any questions about your alimony, reach out, and we'll be glad to help you out.